That was Employment Law 2020. Miss Winter is the head of HR. Precisely with the challenges of the pandemic in mind, she arranged a video conference with her certified expert for labor law, Mr. Jones. Mr. Jones explained to her the most important changes of the year. Do you still remember? Mr. Jones reminds Miss Winter about the CJEU's 2019 ruling on recording working time. This year, he has news from the labor court in Emden regarding this matter. The case: a construction helper had sued for outstanding compensation. He recorded 195 hours in his own hourly report. The employer had recorded only 183 hours in the construction diary. They didn't want to pay him more than that. Emden's labor court ruled otherwise. The construction diary is not an objective, reliable, and accessible system for recording working time as required by the CJEU. Therefore, the hours that the employee has claimed are deemed to be conceded. Mr. Jones's practical tip: even for receiving short time allowance, it is extremely important to substantively document working time. However, in Mr. Jones's view, there is still no need for comprehensive working time documentation according to the current legal situation. Speaking of short-time work, Miss Winter has a very relevant follow-up question. She just received a wonderful job application. In spite of short-time work, can she hire a new person? It depends. Mr. Jones explains, there must be a factual reason for doing so during short-time work. Otherwise, Miss Winter runs the risk of the employment agency no longer granting a short-time allowance. There is even the risk of having to pay back the funds. Mr. Jones's practical tip: after short-time work ends, you can hire a new person without any problems. Miss Winter also has an urgent question regarding home offices. Are her employees entitled to work from home? Mr. Jones explains that the Labor Court of Augsburg made an exciting ruling on the matter in May. In this case, the plaintiff used a medical certificate as a basis for his claim to work at his home office. The Labor Court ruled that there is no legal entitlement to work from home. However, employers are responsible for the safety and health of all their employees. In this context, working from home can definitely be a suitable protective measure. However, it is entirely up to the company's discretion to move an employee to a home office. The same applies for mobile working. Mr. Jones once again makes a clear distinction here. Home office denotes work at a computer workstation that has been permanently established at home by the employer. In that case, the workplace ordinance that regulates employee health and safety applies. Conversely, mobile working is occasional work from home or from the road and is not subject to the workplace ordinance. Miss Winter is excited. Mr. Jones has proven to be a competent partner in employment law matters whenever she needs him. Do you wish to benefit from our advice too? Our attorneys will be happy to assist you.